A very good evening to all my dear students. Good evening and thank you for sending wonderful messages. Good evening, Tambeshwari, Nanda Goel, Lahari Moruju, Pooja, Pallavi, Sanya, Anushka, Raj, and all those who are with us on the portal as well. Good evening, Hardik, Praveen, Pranav, Aisha, Ajisurya, Sondria, Neeru, Manvi, everyone, children. A very, very warm welcome to each one of you. Miss Nancy, Bala Murugan J, Anjali Kashyap, Shruti Kumari, Priti, all of you. Welcome, students. I welcome you all for the second session of our registration of charges. So I hope, like good students, you have revised the previous lecture that we have done. The first part of registration of charges we have already completed. Today we are going to complete. Obviously, we'll be revising what we have done because it's the tiniest, smallest act, but a lot of provisions. When you have the smallest chapter over there in your syllabus and there are too many sections, then it is important to revise each and everything. Am I right? So it becomes necessary to have a quick revision of whatever we have done in the previous class. And today we are going to wind up this chapter. We'll be finishing the section 77 till section 86. All these sections will be covered. And also, as promised, I'll be taking up your queries for acceptance of deposits. Hardik has mentioned in the last class, question number 10, and other questions also from the study material. We'll have a quick review of all those questions. But first, we will complete the chapter of registration of charges, and then we will have a quick revision of deposits also, looking at the permission of the time. All right. So any doubts still here, students, till the previous lecture that we have taken? I think we have discussed all the doubts also in the previous class. So let's have a quick revision. The charge basically means the interest that the other party is having in your property. So when I have taken a loan or a borrowing from another company or a bank, and the security that I have given to them means I have created a charge. So do we need to get this charge registered? So now your test charts, because it is your revision, you have to answer me. I'm just going to ask you questions. So all of you are correct, ma'am. Yes, registration of charge is important. Then only it is said to be a secured charge. Excellent. Shruti says, yes, ma'am, it is the responsibility of company. Hardik says, excellent. The charge has to be registered within 30 days. And what happens if you fail to register the charge in 30 days? We have done section 77. So if you fail to register the charge in first 30 days, what will happen? You have the time period of another 30 days after paying the additional fees. This is what you should have written. So we can register it within very good Pranav, within 60 days from the date of creation. So first 30 days by paying the normal fees. You fail to register, then next 30 days with the additional fees. And still, if you fail to register, then within next 60 days, by what fees do you have to pay? First 30 days, you have not done. Another 30 days with additional fees. Excellent. Nanda Goel, Hardik, Pallavi, Aisha, ad valorem fees. Very good. So within next 60 days, you have to pay the ad valorem fees. And what was the meaning of ad valorem fees? That is the fees which is charged as a percentage of the value of transaction. Depending upon the value, whatever is the loan value that you have taken, on the basis of that, the percentage is computed. That is known as ad valorem. And what are the types of charges? What is the difference between fixed charge and floating charge? Yes, students, we have done fixed charge, plant and machinery, office buildings, all these are the fixed charges, specific assets, and there was a floating charge. Can I use the fixed charge? Even if I have given it as a security? Yes, ma'am, everyone is correct. But can I sell the fixed charge? Can I sell the plant and machinery which I have given as a security? The answer was no, you cannot sell it. But then section 79 will tell you what happens if you sell it. That is what we're going to cover in detail today. And floating charges, all of you have written beautifully. Yes, ma'am. Floating charges can be sold as well as used. So if I have given my raw material, if consent is given by lender, excellent, Hardik Marwa. Very good. So you remember that only if the consent is given, then only in case of fixed charge, you can sell it. Excellent, Lahari, Moruju, Manoj, nice, good answer. Pooja, everyone is correct. So there is a question for all of you. A raw material has been given as a floating charge for the loan which the organization has taken. And if I sell the raw material to Mr. B, so Mr. B will now pay my loan because my raw material has been sold, or I am the borrower in company, I only have to pay them. So if the floating charge can be used and can also be sold, you said. Aisha, the first one to say no. Very good. Only the borrower, because buyer is getting it free of charge. Very good. Excellent. Only the borrowing company will be paying it. So it was just a random quick question that came to my mind just for revising the chapter. So fixed and floating charges, everyone is clear. What was the meaning of crystallization of floating charge? Have we done crystallization? So floating charge can be crystallized and it can become a fixed charge in 4 different cases: when the terms and conditions changes, when the creditor enforces the security, company goes into liquidation, or the company is closing its business, then the lender will become scared and he will freeze the charges. Wonderful answers given by all of you. And the last question that I wanted to ask you, I was thinking to ask it as a question answer round only, but let's do the verification from here only. So every company's responsibility, and what are the forms that you will use for registration of charges? I have shown you certain forms also. CH1 is the form which is used for getting the charge register. And why do we use CH9? CH9 is the form which is specifically used for debentures. And the copy of the instrument shall be signed by different consequences were given if the property is situated outside India. Then who is going to verify the property? CH1, CH9. Wonderful answers given by whole of the class. Let me see over here also on the portal if you're giving the correct answers. Very good. VB Aisha, Pala Murugan, Nancy, Joa Praveen, all of you are giving the correct answers. Wonderful. Okay. Correct. CHG1 form was only for the registration of charges. All of you have given correct. And here the signatures that you're answering, director and CS if the property is situated inside India. If the property is outside India, then company seal, director, CS, as well as the authorized. In both the cases, authorized person of the charge holder also, if the charge holder is getting the charges registered. And this was the differences that we have done before 2nd November 2018, 30 days and 300 days. And after 2nd November, this also we have done. So duty to register the charges, extension of time limit, there was a topic which we have discussed. For taking the extension, a declaration has to be given. What was this declaration, children? So there was a company which had to get the charge registered. They have taken the loan on 1st January and by 31st January, they were supposed to get the charge registered with the ROC. Now the company failed to get it registered within 30 days and want the extension of time period for next 30 days. The company will file a declaration that it will not affect the rights of the other creditors. Means there was Mr. X from whom I have taken a loan. And there is Mr. Y from whom I have taken a loan. And if this loan was taken in the month of July and this loan was taken in the month of August, so if Mr. X's loan has got registered, the charge has been registered. And now if you're asking for the extension for Mr. Y, it will not affect the rights of Mr. X. Other intervening creditors will not be affected. Such declaration has to be filed by the company. Very good. Pallavi Jha has written creditors shall not be affected. Very nice. And others have also agreed to the same thing. Very nice. Now we did after this, and when you have filed CHG1 for registration, ROC will give you which form confirming that the registration of the charges has been done. What is the form to be issued by ROC confirming that the registration has been done? Which form will be used? Excellent. ROC will issue CHG2 showing the fresh registration certificate that the charge is now registered. And children, once this charge is registered, it is posted on the MCA portal. The company has created a charge. It is very much visible. It becomes a public document. It is a conclusive evidence. This certificate which CHG2, which the ROC has issued, it is a conclusive evidence that all the compliance of Chapter 6 and whatever rules are applicable to the registration of charges have been complied with. Children, they are writing something about CHG3 also. Do you remember what was CHG3 about? Was CHG 3 for the registration of charges or anything else? Everyone, 35 new messages. So everyone has written it correctly, CHG 2. And now again, beautiful answers, 56 in the class and 54 messages I've received. Very good. So CHG 3 is for the modification of charges. Wonderful, children. So you are revising your task very nicely. All of you have correctly answered. So I told you in the beginning of this chapter that these forms are going to become very simple for you if you'll revise it and you learn. So can we say that we have very well learned 4 forms at least by now? CH1 and 9 given. You get CHG2 if it is a fresh registration. If it is a modification of the charge, we get CHG3. Modification, we will cover all those points from the study material also today. All right. So the 4 forms we have learned, we have understood, and section 77 is completely done. There was one last part of section 77, subsection 3 and 4, which we were discussing. It says no charge created by the company will be consequences of non-registration. It says now, listen very, very carefully. Thank you so much, Mahi. I'm so happy that you appreciate my efforts, and that is the reason why I put the efforts, because you enjoy doing it, and the credit that I get is that you're learning it well. So well done, all of you. All right. So consequences of non-registration of charges means if the charge is not registered, then the charge becomes void. Now, what is this meaning of void? These are all the words that you have learned in your CA foundation. Void means it has no value in the eyes of law. Means now the charge is unsecured. Now the charge is unsecured. Before we moved on to this point, let me make you clear one thing. When you have given a security for any borrowing, then the person is known as secured creditor. Do you agree? And if no security is given, then the person is an unsecured creditor. At the time of liquidation of company, something which we have been hearing from class 11th and 12th, when the company goes into liquidation, who is paid first? Who is paid first? Always the secured creditors. And balance, whatever is there, is given to the unsecured creditors. Now, consequences of non-registration of charges, very important. I am a company and I have taken a loan from HDFC Bank and I have given my property as a security to the bank. Bank is feeling very happy and secure that now ma'am has taken us a loan of 1 lakh and the property of 2 lakh has been given to us, covering the interest repayment, say 1,50,000, covering the payment of the loan along with the interest. Let's assume. So they are happy that they have something in hand of 1,50,000. Tomorrow, if Arlene ma'am fails to pay 1 lakh, they will sell off 1,50,000 property and they will take their money. All right. But now it is me means company. We are talking about company. This section is applicable only to the company's children, not to the individual. So company has to get the charge register. So I am running a company, Herlene Private Limited. So this company has to now get the charge registered. If I fail to get the charge registered in 30 days, I told you somebody will get unsecured. Somebody will feel that something has not been taken care of. And that person will running and go to ROC and will try to get the charge register. Who was that person, children? Was it the charge holder? Exactly. Section 78 tells us if company fails to do it, the charge holder feels scared and he will go and get the charge register. Now let's assume he also forgot. Nobody went and got this charge register. So now this house which was given as a security is an unsecured creditor. Now HDFC Bank will become unsecured creditor. Earlier he was supposed to get the money of 1,50,000 over here. Now he is part of these unsecured creditors. Means if the charge is not registered, it is equivalent to no property has been given as a security. Now you stand along with the unsecured creditors. Now, even if the liquidator who has been appointed, who is a liquidator? Liquidator is the person who is appointed when the company goes into liquidation. So appointed under the Companies Act or the Insolvency and Bankruptcy Code 2016. You don't have to go into this. You simply have to understand liquidator is the person who is appointed who will take care about how the liquidation is happening. What happens when the company is winding up? All the assets of the company will be disposed of and liabilities will be paid. So when we are paying the liability, secured creditors will be paid first and then unsecured. Now this HDFC Bank will become unsecured debtor. He is not freely, that property is not freely available. That otherwise, what would have he done? If I failed to pay the money, he would have disposed of the property and claimed the money. Now he cannot use that property for selling and claiming of his money. He will have to wait, and the other unsecured creditors are paid. He will also be paid at the same. Is that clear? So it is very important that the charge should be registered. That's why power has been given under Section 78 to the charge holder that you go and get the charge registered if the company fails to do so. All right. Now, another very important aspect. Let me just complete this topic, then you ask your doubts. Nothing will prejudice any contract or obligation for the repayment of the money secured by a charge. Now it says, even if this person keeps on crying in front of the liquidator that, no, please give me that property. She has given the charge in front of me. This is the charge document. It was created. But if it is not registered, liquidator can't help you. If no charge has been created, will be taken. Liquidator will not take into consideration. He'll treat you as the unsecured. But this says that this subsection 3 will not affect the rights of the company to repay the money. Now, I cannot say that I am going to take the benefit. Remember, Lahori Maruju, last time you were asking me about the benefit, whether I'll take or not. So now your point will be more clarified over here. So company will not get the benefit that I have not registered the charge, so I'm free. I will not pay you. Listen, you have not got the charge registered. The other person loses the benefit of selling it off and immediately realizing his money. My liability to repay the loan still remains there. The other party, HDFC Bank, can go to the court. He can take an action against me if I don't repay the money. All right. So the only consequences of non-registration is the charge holder loses his priority. Why he has lost his priority? Because he has become unsecured. Earlier, he was the part of secured creditors. He was standing the first one to get the money. Now he has come under the secured creditors. Now he has fallen in the group of unsecured creditors. So he will not get anything out of that security now. But yes, the liability of the company will still remain. This is very important. Examiner can ask you a question that now since company A has failed to got the charge registered, so you will write about these liquidators point, that becomes unsecured debtor. But now, is it important for the company still to pay? Yes, ma'am, definitely. The repayment of money will not be affected by non-registration of charge. That money has to be repaid. The only consequence is the charge holder loses his right. Is that clear, everyone? Okay. Now let us understand application for registration made by the charge holder. Yes, security is lost. Tribunal appoints. Prejudice means, Nanda Goel, I hope now the point is clear. Prejudice means it's not going to affect them. Okay. Yes, resolution professional Hardik will do at the end of this chapter. Manoj, good. All of you have written the correct points related to this question. Okay. Now section 70. So application for registration of charges by charge holder. Now section 78 says what will happen. The charge holder, now company creating the charge must register the charge, number one. Company fails to do that in 30 days. So 1st of January, I was to have got the charge created. By 31st January, I failed to do. Now on 31st January, so 1st of Feb, the charge holder can go and apply to the registrar. But if company after 31st January is still going and applying for the extension of time, then there is no need of you to. It simply tells you if company has failed within 30 days and still not taking any action, then the charge holder will go and apply to the registrar. Now, what will happen? Let me take an example. There is a company A who has taken loan from Mr. X. Whose responsibility was it to get the charge registered? It was company A's responsibility to get the charge registered. Company A fails to do that in 30 days. Now, Mr. X responsibility that he can go to the registrar. Now, what will happen? Now, here is the registrar. Now, this Mr. X will go to the ROC, the registrar of companies, and he will say that, look, company A has taken loan from me and they have given me this property in Bombay, in Juhu. This property has been given. It has been my name. Please register this charge in my name. Registrar will be surprised that, who are you, Mr. X? How can I register the charge in your favor, which has been created by some other company? So he wants a no objection certificate. Means registrar will send a notice to the company saying that within 14 days, tell me that is there any objection if I register the charge in favor of Mr. X? Mr. X will go to ROC. ROC will send a notice to company. You can write down this point. Company A has taken loan from Mr. X. Company A fails to register the charge. Mr. X will now apply to the registrar. Registrar will send a notice to company. ROC will send a notice to company. And in that notice, it will be written that company, please reply us in next 14 days that you have no objection. If we are this Juhu property, we are creating a charge in favor of Mr. X. Because, you know, anyone can go and do like this. If a company, ROC has to take a confirmation from company that this Mr. X is a valid person. That's why company is sending this notice. So now in 14 days, now what will happen? Now another two things will happen. If company replies in 14 days and says, please don't register this charge in favor of Mr. X, then ROC will not register. They might give the reasons why they don't want you, or maybe they seek extension, that we will take certain extension and we will register ourselves, or any other reasons that he is not a genuine person. We are cancelling a whatever the reasons. Company replies in 14 days and tell them not to register, then they will not register. If company fails to reply in 14 days, then what will happen, children? Then ROC will register this charge. So no objection certificate has to be given by the company. ROC will register. Very good. All of you, Pranav, Hardik, Maruju, all of you have given the correct answer. Company replies in 14 days and says that, so what will happen? ROC will tell the company that, company, listen, either you come and get the charge register yourself, or allow me to register, do the registration on behalf of Mr. X. And you have 14 days time period. Please let me know what you want me to do. If company says, no, please don't do it, ROC will not register. Company does not reply anything, or company says, okay, fine, you do it, then ROC will register this charge. Simple. So let's read it out from here also. So if objection is received, company registered by itself, sufficient cause why such charge should not be registered. Registrar will not allow the registration by the charge. If any objection has been received, then they will not allow. And if no objection has been received, then they will register the charge. Okay. X is a, yes, Chetna. X is a genuine charge holder. That's why we are doing all these kind of formalities. How will ROC come to know that you are a genuine charge holder? That's why they are sending the notice to company A. Okay. If X gives 1 lakh to the company against only machinery worth 1 lakh, after 10 days, company borrowed from Mr. Y. Praveen, you have written such a big essay. You want me to read it out? In this case, after 30 days, you want to register it. So ask your question. You have just given me a picture of case study. What is your exact question? If the ROC informed, then already there. So, Praveen, if you have informed the ROC that the charge is registered, then there is no story of no need of charge holder to go and get the charge registered. Our charge holder will only go if you have failed to register it within 30 days. All right. Now, the first point is this, section 78, that all the story that I've explained to you with the help of arrows and flowchart, that this is what, and no objection has to be received. 14 days is the time period, 30 days for registering, and then a notice sent by ROC to the examiner can ask you questions on these MCQs. ROC will send the notice to the company for giving no objection certificate. This no objection certificate has to be given in 30 days, 60 days, 15 days, or 14 days. Only one answer. All Gurminder Kaur, Sukhveer, Nanda, all of you, Asta, Kushi, 14 days, Neeru, excellent. So how will we remember, ma'am? That time we have studied so many things. We have learned 30 days somewhere. We have learned 15 days somewhere. How will we remember all this? Do you get these kind of doubts in your mind? So let me give you a small hint. How will you remember? This is an important tip. So whenever such kind of question comes, just close your eyes and think about the provision, what you have learned in that provision. Never ever read the options first. The moment the examiner is asking you, okay, the registrar is going to send, to just revise your revision. What was the point written in section 78? Okay, section 78 was telling me what I have learned, that within 30 days I have to send, and then company will send a notice, and within 15 days show cause notice. Okay, I have studied 14 days. Now let me just check it. Whether 14 days option is given, just take it. Don't even read other options. You will 100% confuse yourself if you read the answers to the MCQ first. Always read the question. Think it in your mind, what was the provision, what was the correct answer to this? And you will remember. Don't worry about that. If you have really done hard work always pays, children. You remember, I enjoy telling this saying to my students, and I myself follow this: God help those who help themselves. So when will God help you in the examination? If today you have helped yourself, if you today you have studied well, you have made your notes, you're revising, you're answering back to the teachers, you are making down your notes, you are regularly revising it. God is always there. He's watching you, you are doing it, you're giving your 100%. Definitely you will do good in exams. But if my books are closed and I'm just chilling out, I'm not studying, I'm just listening to these lectures, and then after that, I'm not even opening my books, I'm not revising, then God is watching that also. So always remember, He is watching your actions, and your actions always help to pay you back. If you're doing good, you're studying, revising, definitely you all will pass your exams. All right, so let's move ahead. Okay. Lahari Moroju, don't worry, all the MCQs we'll be covering in the class itself. Thank you so much, Anushka Raj. Yes, I remember that you were there in that respective foundation class also. Okay. Do we have to learn extra 30 days and then? So, Manoj, you can simply remember that for extra 30 days, yes, definitely you have to learn that, because then only you will remember na, that additional fees needs to be paid. So, 60 days from the date of creation is fine. But for first 30 days, you're paying the normal fees. For another 30 days, you're paying the additional fees. And for the balance 60 days, you're paying the ad valorem fees. This is how the sequence you have to learn it. Now, recovery of fees. The registration is affected on the application made by the charge holder. Such person is entitled to recover. Now, what happened? This Mr. X did all the work himself. He went and got the charge registered. It was company's duty actually to get this charge registered. Now, all the fees and expenditures that Mr. X has incurred for getting this charge registered shall be recovered from the company. It says registration made on the application by the charge holder. He is entitled to recover from the company any amount of fees or additional fees, whether in 30 days fees he has paid or next 30 days additional fees paid for the purpose of registration of charges. All these fees he can recover it from the company. So point number 1 will be in your notes, will be the story that how it happens, and point number 2 in your story will be about recovery of fees, that all the fees that the charge holder has paid will be recovered from the company. Why we are recovering it? Because it was the responsibility of company to get this charge register. Because you have not done it, that's why I'm going and getting this charge register. Now, section 79. Section 79 tells you that all the provisions of section 77 will apply if any company is acquiring any property subject to the charge within meaning of section 2 clause 16. So if company A has given their property as a charge to HDFC Bank, and I told you with the permission of the lender, if company A sells this property to company B, so now section 77 will become applicable to this company B. That means now company B will go to the registrar and they will tell them all the procedure of filing documents will again come up, and company B will have to get this charge registered in its own name. So now company A is not going to pay back the money. There has been certain arrangements between company A and company B. Now company B has taken over the charge of that security. One was the case over here when section 77 becomes applicable. Second is in case of any modification in the terms, any modification in the terms and conditions of the contract. So modification means any variation happening in the terms and conditions, including the rate of interest by mutual agreement. So earlier company A was saying that we will pay to HDFC Bank the rate of interest of 7%. Now HDFC Bank says, no, you have to pay the rate of interest of 8%. So all the terms and conditions that they have decided earlier have now undergone changes. So again, for this modification, we will have to file an application under form CHG1. So all these cases where the company is selling the property to someone else, company B will file CHG1 over here, or modifications is happening. Again, these modifications have to be filed in CHG1 only. But the only difference is where the ROC is going to issue the certificate of modification in CHG3. Why not CHG2? Why we are not giving CHG2? Because CHG2 you will get here. When the company B files, you will get CHG2 in your name. That is the fresh certification. And for this modification, the company will get CHG3. All right. Okay, don't worry, Nushka Raj. We will explain this point again from the study material also. Let me explain you from the study material. And those who are asking for Hindi, I will try to explain you in Hindi also. Yes, Nanda Goel, CHG3 form for the modification. That's correct. And I think I remember showing you all these forms also. I have shown you CHG1 and CHG3 in the previous class. Today, I will be showing you CHG4, 5, and even CHG8. I'm planning to show you. So this is your registration of charges, section 77. We have all done all these points, and even the questions were, I think, covered from this. So this is your section 79. After section 80, they have given, I think, yes, consequences of non-registration. So consequences of non-registration, I wanted to cover this example number 6 from the study material, which is very important. And then we will cover this point of section 78 and 79. Okay, first let's do this example 6. Bank A advanced 1 crore to Vasudha Medicos. Again, somebody has written such a big question. And Pooja, yes, you want to ask something. First, let me complete this, Pooja, and then you remind me later on. We'll go to this question, okay? Bank A advanced 1 crore to Vasudha Medicos against the security of company's land and building. So bank has given money, 1 crore to this company, and the company has given the land and building. The charge was created. How is the charge created? By depositing title deeds. So can we say this depositing of title deeds is the interest in the favor of bank, or it is the lien? It is the interest created in the favor of bank. Very good. Lien. Okay. So I told you lien is when you're giving something in possession. When you're giving such kind of documents of title deeds, that means you have given the interest to the bank. Company did not register the charge in 30 days. Subsequently, the charge was registered on 12th August. So 1st June, they are borrowing. So by 30th June, they should have registered. July also passed. And by 12th August, after paying ad valorem fees, means they are not registered by July end also. So next 60 days by paying ad valorem fees. That is fine. Now, meanwhile, Bank B advanced 2 crore to Vasudha Medicos Limited against the security of the same property. So what happened? One property was already given as a security to Bank A. Now, again, 2 crore loan has been taken by giving the same security to Bank B. This charge was duly registered on 26th June 2024. I think, Pooja, your question will also get covered, something that you have asked in that paragraph. So Bank B is now giving the loan on the same property. This charge was registered on 26th June. Now the company goes into liquidation and the property releases only 2 crores. What is happening? Bank A has given money, 1 crore rupees. Bank B has given 2 crore rupees. Whose charge has been registered first? Bank A or Bank B? Answer me. Whose charge got registered? Bank B. Very good. All of you are correct. So who will get the repayment? Now money has been realized at the time of liquidation is 2 crores. So who will get the money first? Here it is not talking about pari passu charges. It is checking whosoever has been charged, has been registered first will get the claim of money. So Bank B will get full repayment. Bank A will not realize anything because subsequent registration in favor of Bank A was done little later. This is the meaning of not affecting the intervening creditors, okay? It says Bank B will get the payment full because 2 crores have been realized. Now he will get the 2 crores because 26 June, it has already been registered. But Bank A will not get anything because subsequent registration will not affect the right of Bank A, which he got in favor. Are you understanding, children? Not prejudice. I explained you that point, that it will not affect the intervening creditors. Means the other bank will not, it will not affect the rights of the banks whose charge has already been registered. Bank B gets the priority over Bank A, even though the charge was created later. It does not mean that Bank A will not get money. Please make sure पेमेंट वापस बैंक ए को भी मिलेगी, बट पहले प्रायोरिटी किसको मिलेगी? जिसका चार्ज पहले रजिस्टर्ड है. समझ आ गया? इन हिंदी ऑल्सो दोज हु वांटेड, सो हुज चार्ज इज रजिस्टर्ड फर्स्ट विल गेट द प्रायोरिटी. Okay, Praveen, I'm glad now you have understood. So example 6 was exactly your question, so I hope you have understood this point. Okay. So again, section 78, we have done all this point. Yes, Bank A, okay, Chetna, Bank A becomes unsecured creditor if they have not registered the charge, but later on they have registered the charge. So, although by that time he will be considered as unsecured creditor, but here I'm simply trying to tell you that even if you get your charge registered late, so extension of time has been taken, declaration has been given, you will still get your money, but the person who has got the charge registered first will first claim the money. Yes, Mahi, title deeds is ownership only. The ownership has been given to them, but that is the definition of charge. I was trying to link it with that. So you have done the definition of charge where I told you it is either an interest or lien created in favor of another. So there we understood the meaning of the word interest, how the interest is given by giving the title deeds. Definitely it is the ownership that has been given. Yes, Lahari Maruju, one asset is acting as a charge for two banks. That is absolutely fine, provided if we have given the pari passu charge or different charges, which you will understand in the modification. Okay. So now let's understand the points of modification of charges, section 79 given over here. So it says company acquiring any property. This all my students are now clear. Section 77, earlier charge will get vacated and its place new charge will get registered. So section 77 simply tries to tell you when company A has sold property to company B, company A has vacated the charge, means they have got free from the charge. There certain arrangements have been made that now company B will pay the money to the bank. Why? Because company B must have paid the money to company A. Now company B will only have to make the money to the bank. Modification of the charges. Modification means changes in any terms and conditions. So certain examples have been given over here. So when the charge is modified by varying the terms and conditions through the agreement. So you and me, lender and the borrowing company made certain agreements. Now we are making any changes in those agreements. Then again, CHG 3 has to be taken from the ROC. For enhancing or decreasing, the enhancing means increasing. If we are modifying the terms of loans, increasing the limits, the loan was to be repaid by 31st January. Now we have decided loan will be repaid by 4th February. So whatever decreasing and increasing the limits. Modification is by ceding a pari passu charge. Now this is important to understand. What is the meaning of pari passu? Pari passu is entitled to a proportionate share in the mortgage property. And when this is ceded, the charge holder will become the second charge holder and entitlement will be subject to full satisfaction of the first charge holder. First, let us understand the meaning of the word pari passu holders. There is company A who has taken loan from bank 1 and bank 2 by mortgaging the same property. There was a house. We have mortgaged the same house. 5 lakhs loan was taken from bank 1 and 7 lakhs loan was taken from bank 2. Now this loan was pari passu charge has been created. Say on liquidation, if the company realized 10 lakh rupees, how is the company going to pay back the money to bank A and bank B or bank 1 or bank 2 in the ratio of 5:7? Pari passu means equal footing, means both these banks have equal interest, will get the equal claims from this property which has been secured. So proportionate share means 5:7 is the ratio in which this amount of loan will be given, will be divided among these two parties. Everyone is clear about this point, that how the pari passu charge has been created. All right. Now what it says, now when it says the pari passu charge is ceded means it has come to an end. When this pari passu, for example, if bank A, company gives priority to HDFC Bank or Bank A, then it will now, company has decided, okay, fine, I am going to give the full priority to Bank 1. Bank 1, let's assume, is the HDFC Bank. So we said that now we are going to give the full priority to Bank 1. Now, this company A will pay out of 10 lakhs, 5 lakhs will be given to Bank 1 and the balance 5 lakhs will be given to Bank B or whatever is the amount, the proportionate, or if the amount is say 4 lakh rupees only. And company A decides to cede the pari passu. Ceded means they have ended the pari passu. Then the charge holder will become second charge holder. Means if company A decides I want to pay entire money to Bank 1 whose charge was registered first, they will get entire 4 lakhs and this Bank 2 will get nothing from that property. But still the money still needs to be paid. So pari passu ceded means if they are trying to change it, if they're trying to altering the charges that have been created in favor. Ceded means ended. Yes. So what about remaining amount, Chaitanya is saying? Chaitanya, whatever the remaining amount, whatever the loans that they have taken along with their interest repayments, that is what is they are going to receive it. Balance amount will remain with the borrowing company. Is that clear, everyone? So if company A gives full priority to Bank 1, then full amount will be given to Bank 1 and nothing will be given to Bank 2 from the security. But will the Bank 2 get the payment of 7 lakhs? Yes or no? Will bank, but still the payment still needs to be paid to Bank 2. Is that clear? In case of a machinery is registered, I understand without the consent of the machine can't be sold. If there is any upgrading of the machinery and the old part has been sold or scrapping, which is all. Praveen, so much complicated things you have written. So even if any alteration has happened, then it will be considered as alteration in the modification in the terms and condition if it is affecting the borrowing company as well as the lender. Okay. Yes, while repayment of interest amount will also be considered, Pallavi Jha, because amount of security, you remember, we always take the amount of security of mortgage that we have taken is always considering the amount of the loan along with the interest payment. If after payment some amount left, then we can pay to bank. Yes, definitely, Hardik. If the balance is still left, we can pay to bank too, but his rights, he loses his rights. Okay, so you don't have to go into much of the details. Example was just to make you understand. I hope you have all understood the meaning of the word pari passu. So, ma'am, what do we have to learn from here? You simply have to learn is, I'll tell you. So you simply have to learn where the modification is ceded by a pari passu chart. Pari passu means equal footing. Ceded means this equal footing is ended. Now it is my choice. How I have ended it is not explained over here. This is just a hint that I've given you that I am going to give priority to Bank 1. So security sold, Bank 1 will get the priority. If anything is left, will be given to Bank 2. Otherwise, Bank 2 will be paid in other ways. Other ways means they can file a court case, but from the security, they cannot claim. All right. Or there is a change in the rate of interest other than bank rate. Now, very important thing. I wanted to tell you one important point. I don't know where we have, how come we have missed it about Reserve Bank of India. Sometimes loans are taken. Okay. Wrong page. Where am I? Let me go to this. Yes. Right is not allowing me. Wait. So, wait, children. Reserve Bank of India, it is written that if sometimes bank has borrowed the money from Reserve Bank of India and bank has given a security to RBI, then these provisions of Section 77 are not applicable to them. How? Here. Rule 3. Rule 3, subsection 5 states that nothing contained in Rule 3. What was in Rule 3? All those provisions of Section 77 that we have done. So Section 77 will not apply to certain charges. It says Section 77 is not applicable to charges which are given in consultation with Reserve Bank of India. Now, what is this, ma'am? So Reserve Bank of India, it says where the charge is required to be created and modified by the banking company in favor of RBI when the loan has been taken from the RBI. So there is, let's assume HDFC Bank has taken a loan from HDFC Bank has taken a loan from RBI. So now HDFC Bank has given certain kind of things as a security to RBI. Now, to this kind of transactions where you're taking money from RBI and the banking company is creating a charge in favor of RBI, provisions of Section 77 are not applicable. There, you will not ask HDFC Bank because banks have the responsibility of doing all these loans and all. So, bank is not required to go and get the charge registered in favor of RBI. Okay, so it says Rule 3 will not be applying to the charges which are created in favor by the banking company in favor of Reserve Bank of India. So, why I have taken you back to this point is because in case of modification, if you'll read, it is written change in the rate of interest other than the bank rates. So other than the bank rates का मतलब ये है कि means यहाँ पे if you are changing the bank rates, then तो anyways it is not applicable. No? Whatever the bank rates, the bank RBI is giving the bank rate, then Section 77 is not applicable. So to others means if company A has taken the money from HDFC Bank and whatever rate the bank has given to them, there the rate of interest are changing, then it will be considered as a modification of charge, but not about the rates between the RBI and the banks. Is that clear? Or if there is any change in the repayment schedule. So the repayment schedule, I told you, you were supposed to pay by 31st January. Now you're paying by 4th February. So change in the repayment schedule. If there is a partial release of the charge on a particular asset, so partially you have paid the loan or partially release has happened, then again modification of charge CHG 3 has to be taken from the ROC. Mahi, they are saying even if security is given from one bank to RBI, then that security is not to be registered with RBI, registered with ROC. Yes, Nanda Goel, if pari passu is cancelled, then if company says bank 1, the first who has been charged has been created, then they will get the payment. Bank 2 will not get the payment from that respective security. Absolutely fine. If company gives full priority to Bank A, Bank B will accept the registration of Bank A is first done. Yes, Lahari Maruju, absolutely correct. So whosoever charge was first done, they will get the money. It will not affect the rights of the other creditors. Okay. All right. So modification of charges, I hope it's also clear to all of you. And certification of modification, we have already discussed. It is done in CHG 3 form. Now, there was a small section 80, which we have left over here. Let's complete section 80 and example 5, then we will take a break. What is the meaning of deemed notice of charge? But before I ask you, before I teach you this topic of deemed notice of charge, I have a question for all of you. When a company gives priority to a specific bank, is that specified bank gets the charge registered first? Lahari Moraju, you're asking something. It means if the company is giving, it's not about the company giving priority to a specific bank. It simply tells you that pari passu has been ceded, means it has ended. So now if bank company is giving priority to any specific bank, then definitely that bank will only claim the money first. Others will be paid in different other ways. Point number 4 of that interest point again. Hardik, which point you want me to explain? You can ask me. Let me just complete the section 80, then we'll come back to it. So before I explain you section 80, I want you to tell me what is the meaning of doctrine of constructive notice. Have you heard about this word? You very well know about this word, doctrine of constructive notice. Do you remember? Section 399. Okay, that's amazing. But what is the meaning of this line? It's a very important section. You must have done it, and you have done it in CA Foundation also with me. When I told you doctrine of constructive notice, you have to tell me first the meaning, then only I'll explain you further. Let me check your knowledge, how much you remember. Okay, Pallavi says MOA and AO are public documents, company's problem, not our problem. Outsiders need to know about the internal affairs, liability to disclose material facts, Avinash. Okay. So now doctrine of constructive notice, now you all have been coming on the same page. So we remember that we have done that whenever any document becomes a public document, means whosoever is entering an agreement or arrangement with the company has supposed to, section 399 tells you that they are supposed to read these public documents. Whosoever deals with the company, it is presumed, it is deemed that they have read it. Is that right? So let's take a very nice, funny example, just on a lighter note. If you go to a restaurant to eat food, and on the outside door, it is written that outside food is not allowed. But still, Avinash and Rachna, when they went to have the food over there, they both carried their tiffins along with that. So now whose fault is it? It is fault of Rachna and Avinash, the students who are here with us in the session. Is it their fault that they have carried the food? Can they say that they have not read it, that it is written outside? Students' fault. Very good. Why? Because they have clearly written it. Now it is your responsibility to read it and come inside. They will not announce it again and again. Is that clear? We all are on the same page. Now you will understand. Now it will become very, very simple for you about the deemed notice of charge. So similarly, when the company registers the charge, means company goes to ROC, all the charges which are registered with the ROC becomes public document. Any person who is trying to lend the money to the company shall refer to MCA portal. I told you once the charge is registered, it goes on the MCA portal, means Ministry of Corporate Affairs website. This charge will be shown and they can go and find out that the charge has been created against this asset. Let's assume there is a company A and there is a lender, Mr. X, in whose favor the charge has been created. This house in Juhu property has been created, the charge in favor of Mr. X, and it is registered with ROC and it is clearly visible at MCA portal. There is another lender, Mr. Y, who is going to give money to company A on the basis of same security. Now, section 80 tells you that it is assumed that company Mr. Y knows that this charge is already created in favor of Mr. X. You cannot tomorrow say that money was given to Mr. X, I did not get anything. It is your problem if you were not sure. Say tomorrow, if you tell the company that, listen, company, I never knew that this charge was registered. You never told me. So company will say, have you read doctrine of constructive notice? These are public documents. I have registered it. I have highlighted it on the MCA portal. It is your responsibility. So the onus and duty, now you will get clear, all those who were asking, ma'am, pari passu will be in favor of whom? So who will pari passu? Both of them will get. But now the charge will go on whose favor? In favor of Mr. X, because the property was first registered in the name of Mr. X. It is responsibility of Mr. Miles. Sometimes the property is having a huge value, na children. Maybe it is 10 crore value of property. Mr. X has given me only a loan of 1 crore. So I can give that property as a security to Mr. Y also. But if any loss happens, if any problem occurs, it is Mr. Y's responsibility. It is his responsibility of the creditors to go and check whether there is any charge in favor of the property against which they are giving a loan. Let the buyer be aware, whenever you're purchasing something, don't you think that it is your responsibility to check if it is free from charges? So the second lender, Mr. Buyer, he gives company. Now company will give the same as security. It is responsibility of company Y, Mr. Y, to go and see whether it is secured or it is free of secured. This is known as deeming provision, means it creates a legal fiction. It creates a legal fiction, means it does not mean that Mr. Y will not be repaid the money. It is only that whenever this property will be sold, who will have the first right on this property, Mr. X or Mr. Y? Mr. X. And yes, Lahari Maruju, it is not company's fault if they have not informed to Mr. X. Why? Because it is clearly appearing on MCA portal. They don't have to tell them. They don't have to inform them. It is responsibility. Please write it down in your notes. It is the onus and responsibility lies on the onus and responsibility lies on the lender. Lender means person who is giving money. On the lender to check whether there is any charge on the property. The onus or responsibility lies on the lender to check if there is any charge on the property which is given as a security. And from where do Mr. Y will check? Mr. Y will see that company A has registered the charge. It is appearing on the MCA portal. It is a constructive notice, means it is assumed that you have the deemed knowledge. Whenever you're dealing with the company, it is assumed that you have read the public documents and now you know about this charge. So never ever company will be at fault. If you are getting this as security, it is your responsibility. Now, another question. if the same property Mr. Z is buying from company A, here the rule of caveat emptor will also come. Mr. Z is buying the same property from company A, then he should check if there is any charge or not from the MCA website. Is that clear, children? So section 80 simply tries to tell you that this is the deeming provision. Yes, definitely company can get loan from individuals also, Lahari Moruju. That's why we are taking examples of Mr. X, Y, and Z. Okay. Company will have to give the title deeds to bank, so it can be twice. Yes, Rachna, so the papers have to be given in the same way and they depend upon how the charge has been created. Nanda Goyal is saying how the company can sell. So I told you that you can sell it if the other party can get the charge in favor of them. What we are trying to understand, listen children, what we are trying to understand in section 80 is that it is a deeming provision. This is a public document. Please, before dealing with me, so Mr. Z will refuse now. If Nanda Goyal, if you are worried that this property is already secured, you will not buy it. Simple. So it is your responsibility to check it, not my responsibility as a company to tell you that, this property is secure. So you might be at a loss. You're right if you're thinking in that way. You might be at a loss. So you will simply refuse to buy. I will be worried to buy a property which is already having a charge because it is given as a security. Tomorrow, if the lender is not going to pay the money, I will have to pay the money. So you have to be very much sure whether you are willing to buy. For that, you have to go to the MCA portal and you have to read it. Now, how this charge reaches at the MCA is actually section 81. So they have told you section 80 briefly first, but section 81 will make the picture more clear. Yes, definitely, Pallavi. And if we still buy, then the charge will get transferred to him and he will have to file Section 77. All the registration has to be done by him again. All right. So please go through the topics till here and then we will quickly wind up this chapter and move on to the doubts of the deposits as well. Thank you. Let's take a small Welcome back, students. I'm audible. All right, Manvi, yes, I'll explain you section 80 again once. If charge holder pay any fees in order to get the charge register, is entitled to receive the same. Yes, Anushka Raj, if charge holder is paying any fees, he will recover it from the company. Yes, this is correct. Okay, good, Nanda, you have understood. Let's proceed, students. But before that, I have made certain small notes for you for section 80. Because since you're getting confused, so I would want you to write it down, these small things, so that you understand section 80 very clearly. So number one thing is that you have written is that section 80, it tells you that this is a constructive notice, means it is a public document. The charge, the person who is entering, the lender, has to read it about in the from the MCA portal. If any charge is created and any person is acquiring, he is deemed to have the notice of the charge. Means the person whosoever is giving money to us on the same property, he is supposed to have read this about this notice. Any person proposing to deal should verify that this asset is already under the charge or not by going through the record of charges at the RO office before entering. So at the office of the registrar of companies where the records are being maintained, they should check it whether this property is charged against or not. Now, children, why section 80 has been made? This is because that is why the registration of charges was done, so that to protect the lenders, so that the borrowing company is not giving the same property again and again. So please write it down. Once the charge is registered, I hope I'm audible to all of you. Once the charge is registered, it is called a deemed notice of charge because it has been posted on the MCA portal. If lender fails to check about this charge from the MCA portal or from the ROC records, it will be considered as lender's mistake. The first charge holder will get the money from the asset which is already secured in his name. That is why registration of charges are done, so that we can protect the lenders and company does not borrow money by giving the same assets, so that the lenders can be protected and company does not borrow money by giving same assets again and again as a security. Example number 5, once we'll do, it will become more clear, children. Vishnu Marketing Limited obtained a term loan of 50 lakh from Alpha Commercial Bank by creating a charge on its office building. So there is a company, Vishnu Marketing Limited, loan has been taken of 50 lakhs from Commercial Bank. Charge has been created and this charge is also registered. Later on, if the building was sold to Neeraj, what will it be presumed? Section 80 says that it is deemed to have the notice of such charge. It is presumed that Neeraj knew beforehand that the building is already mortgaged. Therefore, Neeraj cannot plead against such presumption by saying that he did not know about the charge if he suffers any loss. How will he suffer loss, children? Can you tell me? Can anyone tell me? How can Neeraj suffer any loss? Because if the property which was secured in favor of Alpha Commercial Bank, if all the amount has been given to Alpha Commercial Bank only from realizing and nothing is left from that property for Neeraj, then it is Neeraj's fault because he should have seen it that this property is already secure. Yes, Pooja, he will be required to repay the loan amount. Loan पैसा तो देना ही पड़ेगा मुझे नीरज को, but from that security he cannot claim any money. No, Nanda Goyal, this was not pari passu charge. This is simply telling you that the charge has already been created in favor of someone. It is your responsibility to read it. Few lines before example 6, another important. Okay, I will explain you that also. I hope everyone is now clear for section 80, children. Quickly tell me. Yes, Lahari Maruju, then Neeraj will be liable to pay. Neeraj is not liable to pay. Neeraj is liable to claim the money if he has deemed to know about this money. All right. So another important consequence somebody was asking of non-registration is that the charge holder loses priority. Any subsequent registration, even if it is registered within the extended period, shall not prejudice any right. I have explained you this point, child, from my presentation, that you will lose your priority. Means there is HDFC Bank, SBI Bank. HDFC came on 1st July, SBI came on 1st August. I registered SBI first. So now this SBI Bank will get the money, not HDFC Bank, because it took extension of time. But still the money will be repaid to HDFC Bank also. All right. Good. Ajay, Surya, Shruti, Pallavi, everyone has written clear, ma'am. I'm glad. Aisha, Neeru, all of you have written clear. That's great. Ma'am, page 6.15.4, explain. Okay, 6.15, page number. Point number 4, where there is any, this is Hardik, this is the point that you're asking, where there is any change in the rate of interest. Are you talking about this point? It is a very simple point, child. I was charging 7%, now I'm charging 8%. The rate of interest has changed. So now please, this is a modification. Terms and conditions of loan have changed. File CHG1 again to the ROC and they will give you CHG3 for the modification of charge. Other than bank rate means if bank has taken loan from RBI, any difference between the bank rate that RBI is offering, these rules are not applicable to them. To banking companies who are borrowing, other than bank rate part means banking company who is borrowing money from RBI, to them these provisions are not applicable. All right. Section 81 tells you about the register of charges to be kept. So the register of charges, it contains the provision. Okay, I think I should now take you to my presentation. So these are all the questions which we'll be doing after 8 in the class itself. All these MCQs are framed for you so that you can understand. This is your deeming provision, children. Register of charges simply tries to tell you that the registrar will keep all the registers in respect of the company, how the charges have been maintained. So when you go to the next chapters also, management and administration, there section 88 onwards, you'll understand how the register of members is made, how the register of foreign members is made. So from section 81, the story starts about the register of charges. So a register has to be kept by the registrar in which all the details will be entered, in whose favor the charges have been made. That is how now you can go and check from the MCA portal. That is why they were saying that you can go and check it, because these registers are already being maintained. Particulars of the charges maintained will be at Ministry of Corporate Affairs shall deem to be the deeming provisions of section 81. That means somebody who is dealing is already aware about the charges which has been created. Now, can you inspect these charges? So this deeming provision, it says register is open for inspection. Can anyone come and inspect these charges? Yes, anyone can inspect it by paying the fees. So if I am a member of the company or I'm a creditor who has given the money, then I don't need to pay the fees. I can go and see whether the charge has been registered. But any other person other than the members and creditors, they can pay the fees and they can check the, inspect these registers also. Companies Register of Charges, section 85. Now it says, every company shall keep at its registered office a register of charges in the form number CHG 7. CHG 7. Now, children, we have done CHG 1, CHG 9. Both are given for getting the charge registered. 9 for debentures, 1 for debentures. What does ROC gives us? ROC gives us 2 for registration, fresh registration, 3 for the modification of the charge. CHG 4 and CHG 5, I will be teaching you in a while. That is satisfaction of charge. But let us first complete CHG 7 and CHG 8 because they're very, very simple. CHG 4 and 5 is little longer and I have to show you the forms also. The company will keep the register of charges at the RO office in the form CHG 7 and they shall provided the copy of the instrument will also be kept at the RO. What was the copy of the instrument? Can anyone tell me? What was the copy of instrument? The agreement that we have entered between the borrowing company and the lender. This instrument, this document, agreement. Yes, this document shall also be kept with the RO office along with the register of charges. And what all details shall be open for inspection during the business hours? Members and debtors don't need to pay any fees. Other persons need to pay the fees. Provisions of Rule 10 are company will enter in the register the particulars of all the charges created, what is the property and assets against which the charge has been created, any modification made, all these things. All the modifications and satisfaction of charge. Satisfaction of charge means, I hope I'm audible. I don't know why it's getting muted in between. I'm audible, children? Okay. Yes, title deeds, very good. So about all the details about the charges which has been registered, which property has been given as a security, who are my lenders, all the names of the people will be entered in the register of charges. Basically, it is the entry that you're making in the register of charges. Like your teacher used to come in the school, she used to carry a register of attendance, all the names of the students, all their email address, everything is added. Similarly, for the register of charges, all the particulars related to that particular chart are entered over there. And what is the meaning of satisfaction of charge? Means you have paid off the money. You have written off this charge. Means satisfaction of charge will happen if I have repaid the loan, then my property against that charge will be released. All these details will be mentioned in the register of charges. And what is the form in which the register of charges have to be maintained, children? Quickly answer me. Yes, director will inspect after paying fees. Absolutely. Director is a member. He will not pay the fees, beta. CHG 7 is the correct answer. Who is asking directors need to pay the fees? Director is not a member of the company, do you think? Huh? So any entries are made forthwith after the creation, modification, and satisfaction. So forthwith means immediately. As soon as the charge is created, make the entry. As soon as it is modified, CHG 3, make the entry. As soon as satisfaction of charge happen under CHG 4 and 5, make the entry in the register of members. Entries will be authenticated. What is the meaning of authenticated? They will be signed. They will be signed by the director or company secretary or any other person authorized by the board. So entries in the register will be authenticated, means they will be supported, they will be signed by the director or the company secretary. So director is himself authenticating. So they have the power that is in their hand only to see the register of charges. And for how long these registration of charges are preserved? They will be preserved permanently. Permanently means forever. Forever you will keep these records with yourself. And the instrument for creating a charge or modification will be preserved for a period of 8 years. So let me give you a small hint. All these registers which you have been learning so far, maximum period generally is given for 8 years. There are only 3 to 4 registers like register of members or register of foreign members or one register that you have learned about section 7 incorporation of company you would have done. All those documents are maintained till the date of dissolution. Other than these, most of the time, all the registers are maintained for maximum period of 8 years. Okay, but the charges register will be maintained permanent. Yes, Nanda Goel, absolutely. Company paid the debt and get the charge released. Absolutely correct. Is that clear, children? Section 85 is clear to all of you. Register of charges is very, very simple provision. Learn it now and then finish it. Now we are going to do section 82, that is satisfaction of charges. And after that, we will be doing section 83. Okay, let us complete section 82 and 83. Now, all the eyes and ears here, please. Let me see those students who are with us on the portal. Are they understanding? Bala Murugan, Joa, Nancy. Yes, Nancy Hingu, correct. Inspection can be done. Good. Joa, Praveen, all of you are giving the correct answers and the students here are anyways doing it very well. I have a doubt in the... Okay, Hardik, ask your doubt. Good, Abhishek Mishra, I'm glad you've understood. Yes, Hardik, you want to speak?
Good evening, ma'am. Ma'am, in that example 5, the loss suffered by Vishnu, by Neeraj. Ma'am, that loss suffered, uh, the payment of the loan will be done by Neeraj only, no? Or it will be done by the company?
Who has given the loan? Neeraj or company?
Ma'am, company has taken the loan.
From?
Alpha Commercial Bank.
And then after that from?
Ma'am,
On the
only one thing is,
security from Neeraj, right?
yes, ma'am, and then he has sold the security to Neeraj. Then,
Yes.
ma'am, the responsibility of the loan will be on Neeraj only, no?
Yes, if he has not seen the charge, see what that example is trying to tell you, that tomorrow, how will Neeraj face a loss? Because Neeraj will be asked to repay the loan bank to the bank after that. So now he cannot say that I never knew that this property is secure. It is his fault. Definitely, he will have to pay back to the bank.
Yes, ma'am.
All
So,
right?
so the responsibility of the loan and the payment of the loan is on Neeraj now.
Yes, it will be on Neeraj.
Okay, ma'am. Thank
Okay.
you.
All right, not an issue. All right, let's proceed ahead. Company to report the satisfaction of charge. So what is the meaning of satisfaction of charges? Means now the company has paid back the loan and now the charge is satisfied, means it is paid off. So there is a company that has borrowed 1 crore rupees from bank. There is a company Reliance. It has borrowed 1 crore rupees from HDFC Bank, and now property was given as a security. If Reliance has repaid 1 crore rupees, is there still any security? No, ma'am, this security now gets released. So when they repay the loan bank to HDFC Bank, it is the satisfaction of charge. Things are finished. Now the company will give the intimation in CHG 4 form within 30 days of this payment. So on 1st January 23, Reliance has taken a loan and created a charge. So this charge was to be registered with ROC in first 30 days. We understood 31st Jan with the normal fees. Beyond that, next 30 days, additional fees. Beyond that, 60 days, ad valorem fees. Everyone is clear on that, section 77. Now there is a reverse story. Now you have paid the money. So let's assume on 1st December 2023, Reliance repaid the loan back to HDFC Bank. So within how many days CHG 4 needs to be filed with ROC? Answer me. Within how many days? Within 30 days. So by 31st December 23, Reliance will file the form CHG 4 with ROC that, listen, we have paid off the debts. Now this property is free. Now, whether Neeraj is coming or purchasing it, or anybody else, Mr. Z in our example is purchasing, or any other person is taking it as a loan, they are free to take this property because ROC has been informed in CHG 4 that this property is now free from charge. Understood, children? This much is correct. Extended period of intimation. Again, now this company Reliance has failed to inform within 30 days, then 300 days from the date of satisfaction. So how many additional days do you get? Same provision which was given under before 2nd November 2018. Okay. Students, just give me 1 minute, please. Yes, students, there's little small disturbance in the internet. That's why it's just getting. Yes. So it says extended period. So additional 270 days will be 300 days will be given from the date of satisfaction of charge. So what is the additional days? Everyone has correctly answered. 270 days will be given for the additional days in order to get this CHG 4 form registered. Notice of the holder of the charge by the registrar. Registrar will now what will happen? The reverse story will happen. The charge holder was coming and telling you that please register this charge, and the registrar was giving the notice to the company. Now this company is saying that release this charge. Now the registrar will give the notice to that bank, HDFC Bank, the charge holder. Listen, HDFC Bank, there was a charge created in favor of you. This company Reliance has come to my office and they're telling us to release the property. Are you satisfied? Has your money been paid off? I give you time of 14 days to tell me why this satisfaction should not be recorded. And if no show cause notice has been sent, this satisfaction of charge will be recorded. And if any show cause has been done, then it will not be given effect by the registrar. So have you understood, children, section 82 vis-a-vis section 77, same stories, not section 77, section 78. Their charge holder has gone, 14 days show cause notice was sent to the company. Here, company has gone that please release this property, satisfaction is done. To whom the registrar is sending the notice? Here, the notice will be sent to the, answer me, hurry up. For no objection. Very good, Rashna. To the bank. So what do we call Pallavi Jha? The bank is the charge holder. So notice will be given. And within how many days the bank has to reply that this satisfaction should be done or it should not be done? Quickly tell me the time period. Within 14 days. Excellent. All of you have answered it beautifully. And if the charge has been fully paid. So there is a small thing that I wanted to tell you over here is there is a difference between the words loan. Children, sometimes the word satisfaction is broader. Say, for example, I've given you the Juhu property earlier. Now I'm giving you some other property in lieu of that. So satisfaction means by any way the other party has been repaid. The money has been paid. Either the property has been charged, has been created in favor of another charge, or realization of charge has happened, or the repayment has been made. In both the ways, it will be counted as the satisfaction of charge has been done perfectly, nicely. And what will the registrar now issue? Registrar will issue the certification of registration of satisfaction of the charge in CHG 5 form. And again, these records will be maintained for a period of 8 years. Is that clear? So company will give the intimation within 30 days. Registrar will send the notice in 14 days. If no show cause notice has been done, he will inform the company. No notice in case the intimation has been sent shall be signed by the holder. Now, this is important. What is the exception? It says there is an exception. Say, for example, CHG 4 form that I'm sending to the company that look, my satisfaction of charge has happened. I have paid off this money. And this is already signed by HDFC Bank also. Then ROC will not go and tell the banker that, listen, give me the no objection certificate. Okay. Children, I'll take a small 5 minutes break over here. Just go through this section and then I'll ask you questions. Yes, students, welcome back. And I'm very sorry for this little delay, but we'll carry on the lecture a little longer today. Okay, ROC will have to keep the charge in Form 1 and 9, whereas company in CHG 7, Nanda Goel, that is absolutely correct. So that means you have understood how the ROC is going to maintain the register will be in CHG 7. Let's proceed further. The registrar, any doubts still here, students? You can talk to me if you want to ask anything. What inspection of register is done by whom? So the inspection, Manvi, inspection can be if someone wants to see whether the register has been maintained correctly, whether the entries have been made nicely or not. So members without fees, but any other person by fees can do it. If show cause notice was not given, ROC will register. And if it, yes, Nanda Goel, that's correct. If the asset is provided as a security, it will get self-registered. Lahari Maruju, if you're asking me, it cannot be again charged as a security. Listen, child, I can give my asset as a security to different lenders, provided the value of the security should always be more than the amount of loan taken. It is the responsibility of the second lender to check whether the value of the property which has been secured earlier or not from the MCA portal. All right, Lahari, I hope you're clear now. Any other doubts, children? What is this 300 days? Sanya is asking. So 300 days is the extension. I failed to give you satisfaction of charge in first 30 days. So now another 270 days extension is given to me. That is 300 days from the date of creation. I can inform ROC in CHG4 form that my charge has been satisfied. Now, let us go through these company to report satisfaction of charges in the prescribed form. Here it is showing you the inspection of registers in 300 days. So it is written that if you fail to do it on the application made, then further 300 days, not further 300 days, 300 days from the date of satisfaction. So additional 270 days is given. Why is it that security? Anushka Raj is saying why security must be higher. Anushka Raj, you answer me one thing. You gave me a loan of 10 rupees and I gave you security of 5 rupees. Will it be justified? लोन आई हैव टेकन मनी, जो मैंने आपसे पैसा लिया वो 10 रुपए लिया, आपको मैंने सिक्योरिटी के लिए 5 रुपीज की चीज दी, तो जब मैं पैसा नहीं दूंगी तो आप मेरी सिक्योरिटी को सेल करोगे तो आपके पास कितने रुपीज आएंगे? 5 रुपीज. आपको हमेशा ज्यादा अमाउंट की सिक्योरिटी लेनी पड़ेगी ताकि आपको जो पैसा रिकवरी पे मिले वो ज्यादा हो. ओके, आई होप यू हैव अंडरस्टूड. आई हैव एक्सप्लेन्ड इन हिंदी आल्सो नाउ. The loan should be twice as the loan value amount. Okay. Please explain paragraph 6.11 before example 5. Okay. I will explain you. Let's do the doubts first and then we'll proceed. Point page number 6.11. Which point you want to ask over here, Bicha? This is point number 611, page number 611. If he enters into transaction without making inquiry, are you asking about this point? Lahari Moruji, which paragraph are you asking? Quickly, hurry up, tell me. If the charge holder register the charge, can it? Yes, Pooja, he can recover the money from the company. Manvi, it is for both the companies, the 300 days. Compulsory registration also acts as a method of preventing the company from offering. I have made you write it down, this line also, child. That is why the registration of charge is compulsory, so that you cannot give your same assets again and again to avoid the fraudulent funding. See, for example, I have a property which is worth 1 crore. I have taken a loan from HDFC Bank for 90 lakh rupees and given that property, considering the valuation done by the register valuer, that property I have given as a security. Now, if I fail to pay 90 lakh, HDFC Bank will sell that house and recover the money. But I am trying to cheat people. I'm trying to give it to different lenders, the same property. Then such kind of fraudulent funding should be avoided. How it will be avoided? Lender B will come. He will go on the MCA portal. He will check that her lien give me money. So that is how security will be given to the lenders. They will be secured. They already know from the MC portal. But if they don't check it and they agree and they come in my fraudulent funding, I've borrowed the monies fraudulently and I've given them the same security, then I will not be at fault. It is their fault. Although I still have to repay the money. There is no excuse of not repaying the money. Money has to be repaid. It is only about the recovering of the money from that security. Is that clear now? Everyone is clear about this? And section 80, whatever I've made you write it down, that is more important. If you have understood that example and paragraph that I've made you write down, that is sufficient. If the asset is once given in Ministry of Corporate Affairs portal website, then it can only be given as a security. Say, for example, that house was for 1 crore. I have taken a loan of 40 lakhs. I can another loan of 40 lakhs for the same property. It can be done, provided the registered valuation has been done by the registered valuer. The property security is sufficiently available to cover the loans. Okay. All right. So I hope everyone is now clear about this. Let's proceed ahead. The satisfaction of charges we were trying to cover from this module. Now the registers are everyone clear? CHG 7 that you have to maintain. CHG 4 is important. I was trying to tell you, if no show cause notice, then we will register. If show cause notice, then we will not register. Issue of certificate will be done in CHG 5 form and preservation of records will be done for 8 years. Now there is a small section, section 83. After doing section 83, I'm going to show you the other forms also, CHG 4 and CHG 5. Section 83 is very interesting. First, you listen to the story that I'm going to tell you. Then we will do it from the book. So I told you that Reliance paid off the money of HDFC Bank. Satisfaction of charge done. In which form did you send the notice in 30 days? Quickly tell me. When Reliance repaid the money to HDFC Bank, ma'am, we use CHG 4 form. Very good. Excellent. Everyone has told it correctly. And which form ROC gave you for record of satisfaction of charges? CHG 5. Excellent. Now listen carefully. Pranav, Pallavi, Nanda, Lahari, Moruju, everybody, Hardik, Neeru, correct. Correct answers. So now, company paid off the money, loan is repaid, property is released, property is free. But company did not tell ROC. Somebody else, my neighbors, they went and told ROC, listen ROC, Harleen ma'am borrowed loan from HDFC, now she has paid off the loan, that property is now released. Some intimation has been received from someone else. Absence of intimation from company means company did not tell ROC, but ROC came to know from someone else. Then power has been given to ROC that suo moto you can issue CHG 5. It says, registrar, listen. Company was coming to you in CHG 4. Then you were issuing CHG 5. Now company forgot. Company, super duper company, it forgot to tell you that the property is released, free it from, issue the certification of satisfaction of charge. It forgot to tell you. Absence of intimation. But somebody else told you, or the registrar came to know that this satisfaction of charge has happened. Then power has been given to the registrar to make this entry of satisfaction and issue CHG 5 form. This is only what section 83 tells you. Now let us read. Section 83 empowers registrar to make the entries with respect to the satisfaction and release of charges, even if no intimation has been received. So point number 1, no intimation received, still the ROC has the power to do it. Situation arises when the property subject to charge is sold to third party. Neither the company nor the charge holder has intimated regarding. So now your property has been sold. Nobody has told that the property 1 crore, which I have given to HDFC Bank, now I have repaid the loan. This property is free of charge. I have sold it to Lahari Moruju, the one who's asking so many doubts. So Lahari Moruju has purchased that property. Now that is free of charge. You have paid me 1 crore and you have taken that property. ROC is like, nobody told me about this. So I will issue CH5. Okay, Harleen ma'am, here is your CHG 5. This company has now been released off, has given the satisfaction of the earlier charge. All right, clear? Point 2, 2 points clear. Let's read the third point. With respect to the registered charge, if evidence is shown, evidence has to be shown. Where are the papers? How can you prove the papers? Evidence has been shown that the satisfaction has been done, the debt secured has been paid, or satisfied wholly or in part of that property, or undertaking has been released from the charge, has ceased to form part of company's asset, then he will enter in his register that debt has been satisfied or part of the property has been released. Whatever is the case. Whole building, 2 floors were secured, 2 floors have been sold off, paid off, satisfaction, part of the property. Whole of the debt, 1 crore has been paid, whole of the debt. Whatever is there, simple 83 section gives power to ROC that if company fails to give CHG 4, chup chap se, if you have come to know, issue CHG 5. But registrar, gives the power to the registrar to issue CHG 5 if company has failed to tell. But registrar generally doesn't require to use this power. It is only the power which has given to him. Most of the cases, a registrar company will only go and tell them, then only they will issue CHG 5. According to section 82 will not affect the power of the registrar to make the entries under 83, otherwise than on receipt of intimation. If no intimation is received, section 82 simply tells you that he will make the entry only when section 83 will apply, only when the generally intimation from the company will come, or otherwise. Even if no intimation has been received, somebody else has told you, evidence is important. Some evidence will be there, then only you will come to know that satisfaction of charge has happened. Somebody is just saying, ma'am, please release the charge. Registrar, please make them free. How will you do it? You need evidence. Then only you can do that. So registrar will inform the infected party. Now registrar will inform the infected parties within 30 days. So registrar will quietly make the entry. He'll see the evidence and he is responsible to inform them in 30 days that, look, we are making this entry of satisfaction of charge in your register. Yes, Pooja, that is what we're doing. ROC is giving the ROC is not giving the intimation. He is simply issuing CHG 5. See here, we are issuing CHG 5 that your satisfaction of charge in full has happened. So what do you have to remember in section 83? No intimation received from company. Somebody else told ROC, or ROC came to know through some evidence that the charge has been released. Whole of the debt has been paid or part of the property has been released. ROC will issue CHG 5 on its own. Suo moto. लिख के रख लेना कहीं पे. Suo moto ROC is issued. All right. Now let's move ahead. Appointment of manager or receiver under section 84. First, let's complete the syllabus. Then we have a lot of time. We have certain questions also, and we will do the query sessions also. Section 84 simply tells you that sometimes there is a fight between two people, that Mr. A and B are fighting that who will take care of this property which is charged. So a receiver is appointed by the court. Remember, in case of insolvency, official assignee is appointed by the court. Similarly, whenever there is a property against which the charge has been created, sometimes we need the orders of the court for the receiver to be appointed who will manage this property. So a person obtains the order of the court, say if charge holder is worried that I'm really worried this borrowing company will misuse my property. So I want some receiver to be appointed for this property. So he will take the court's order and a receiver will be appointed under section 84. Or if any person appoints the receiver under the power given under the instrument. Instrument means the loan agreement, or if it is given in the loan agreement that this is the Juhu property, some receiver will be appointed who will be taking care of this property which is secure. Either the court's order is taken, number one, court's order, likhte jaya karo note side by side if I'm giving you different words. Court's order, number two, as per the loan agreement, they have decided to appoint the receiver or manager. Then again, within 30 days, inform ROC. Simple, within 30 days, please tell ROC that registrar that we have given the notice that this person is appointed who will be taking the care of the property. On the payment of such fees and register the particulars, now he will again enter the name in the register of charges. That's fine. And when he ceases to hold, what is the meaning of ceasing to hold? When he leaves it, when he has gone, he is no more holding the property, please inform the registrar again. Simple. So what is section 84? Receiver or manager is appointed either by court's order or as per the terms of the agreement of the loan. Inform registrar in 30 days. When he is gone, again inform the registrar. Is that clear to everyone? Lahari Moruju, I'm not looking at the doubts right now. We are first finishing up the syllabus. At the end, you have to remind. Is that Ivan? I'm not getting yes, ma'am. What happened, students? Are you there? Who can appoint it like a charge holder? Yes, Hardik, charge holder can appoint it. If somebody is worried that you will misuse the property which you have given as a security, then he can take the order from the court and appoint a receiver or a manager who will take care of the property. And within how many days? So this, did you understand the beauty of this chapter? Everywhere 30 days is used. The only place where 14 days are used, my dear students are going to tell you. Just listening and enjoying the session, it's your time. Everywhere it is using 30 days. Before 2nd November 2018, and in the satisfaction of charges, it is using 300 days. Two places where it is using 14 days. Very good. Rachna says, ma'am, two places. Where? Hardik says, notice of confirmation given by ROC. Section 77. Avinash is safe. Ma'am, section 77, somewhere 14 days when it was written. Please go and figure it out. Very good. Lahari says, when the lender gets the charge register. Very good. Excellent. Show cause notice. Receiver is appointed. Nanda, that is 30 days. I'm asking 14 days. You're telling me receiver is appointed to take care. 30 days we have to inform. Listen to the question carefully. I'm asking, when is 14 days provision used? Chetna, right? Satisfaction, charge is satisfied and the charge holder is registered. Excellent. Shruti Kumari, when no objection certificate is required. Very good. So that is the only place. Now, when you make the notes of these chapters, now on the beginning of the chapter, write these small points. 14 days on these two cases, otherwise 30 days, 300 days, 60 days. Aaj hi bana lena apne notes because the chapter is fresh in your mind. And when you make your notes with your hands written, you will never ever forget the topics. All right? Okay. Punishment for contravention, section 86. Now, this punishment is important because there is only single penalty. Never ever leave the punishments of chapter number 4, chapter number 5, that is acceptance of deposits, and chapter number 6, because they're having very small penalties, so you have to learn them. So if you contravene the provisions of registration of charges, 5 lakh is the penalty for the company, and every officer is 50,000. And you do any kind of fraud, false, incorrect information, suppressing the material information, then which section becomes applicable, children? If you're giving any false, section 447. I'm not revising 447 now. You all remember imprisonment on all those cases. 447 is very important. Given in the end of the chapter 3 prospectus, you have to learn 447. Okay. And the last section for today, that is section 87, rectification by central government. Now, central government, what happens in this section? Let me take you to my presentation. So till here, all the sections are clear, children. Please tell me. Till section 86, everything is clear? Anyone has any doubts before we go to section 87? Lahari Maruju, can you just speak and ask your doubt because it's not clear what you have written? Yes, he can be another new lender also. Okay, you're asking in section 83, can a new lender also go further and tell them? So yes, it can be a new lender also, so that he is finally feeling relaxed that this property is free from the charge. He can also go and take the intimation. That is correct. Nanda is saying receiver is appointed to take care of it. Yes, obviously he is appointed to take care of the property. What else are you expecting him to do it? Okay, that's correct. Okay. So I'm not seeing any more doubts. That means till section 86, everything's clear. Now I'll be asking you MCQs and questions also, okay? All right, let's finish it off with section 87. Rectification by central government. Now in this chapter, central government is also coming and he will try to see whether is there any need of making rectification in the register of charges. So section 86 told you, children, that if there is any default, if there is any punishment, penalty will be charged. But say if central government feels that certain rectification, what is the meaning of rectification? Rectification means to correct the errors. Sometimes there is any omission in giving the information or any misstatement has been made in the registrar's information that you have given, then central government can order for the rectification to be done. Ma'am, what is this? We do not understand. What is this omission, misstatement? Are you teaching us prospectus? No, we are here only in registration of charges. Let me make you understand each and every word and line with the help of example. Company A has given two properties as a security, property 1 and property 2. When company A was filling CHG1 form with the ROC, it gave information about property 1 but failed to tell them about property 2. Omit हो गया by mistake, गलती से mistake. not doing it intentionally, accidentally this thing happened. Or there was a misstatement. The address, this was Juhu property, this was Bandra property, but they have given it a wrong address. Misstatement has happened. Or instead of telling plant and machinery was secured and office building was secured, they have told that only office building is secured, plant is not secured. So some misstatement has happened or some omission has happened, which is a mistake made, which has happened by mistake. Then central government has to be satisfied that this mistake was only an omission. It was only accidentally which has happened, not intentionally. Then central government will say, okay, allow them some time to make the rectification in the register of charges. Such can be related to filing of the charges or any modification with respect to the satisfaction of charges or any other entry. So it is applicable to all the sections. Wherever you were making a satisfaction of charge, or you were filing the case for modification of charges, or you were taking a fresh registration, in whatever case, if you have made any mistake, central government can pass the order for allowing you to rectify those mistakes. The time for giving the intimation of payment of satisfaction shall be extended, or the omission of misstatement. Central government needs to be satisfied. Where you're asking for the time for extension of money, please, I forgot to give it in 30 days. Allow me the declaration to be given for beyond time, or any omission misstatement. Central government has to be satisfied that this default was accidental due to inadvertence because of some other sufficient reasons and will not affect. Prejudice means it will not prejudice the position. It is not going to affect my creditors and shareholders. You're not doing anything fraudulently. Simple. Galti se mistake is the word that my students have to learn over here, but don't write in exam this in the abbreviations, okay? So accidental mistake. So which application will be filed by the company for this? CHG 8 will be used, and the order of rectification will be made by the central government on some terms which are just and expedient, means whatever he thinks fit, he will pass his orders as per that. So section 87, who will give me a summary of section 87? You made mistakes. Rectifications means any changes. Yes, Anushka Raj, rectification means error ko correct karna, corrections, modifications karna. Rachna, Nanda, Pooja, all of you are correct. So number 1, you made omission or misstatement in filing or registration of charges or recording of the satisfaction, or for extending of the time limit that you're asking. These mistakes were made accidentally. You have not inadvertently affected. You were not doing it intentional mistakes. It is not affecting the position of creditors and shareholders. Then what will happen? Central government, you will make an application to the central government. Central government will pass the order allowing the company to do the rectification of the register of charges. He will pass the order, whatever he thinks fit. Is that clear? With this, we come to an end of registration of charges. Here is a small question for you. Beauty Limited obtains the working capital loan from nationalized bank against the hypothecation of stocks and accounts receivable. So stocks and accounts means current assets are being secured. Instrument creating charge was duly signed by the company and the bank. Company is not willing to register the charges. Is there any provision which can allow the charge holder to get the charges registered? Please tell me, student, this Beauty Limited it failed to file the registration of charges. Can the bank go and get the charge register? Yes or no? Tell me. Ma'am, such easy questions will come in the exam, then we'll all will pass. It is easy because you're doing it right now in front of me. You're learning and understanding. Excellent answer, section 78. I'm so super happy to read the sections also. Harshpreet Kaur, Rachna, Shruti, Dilip, Ajay Surya, Nanda Goyal, Anushka Raj. All of you are giving the correct answers. Wonderful. So, okay, now tell me, can the registrar refuse also? Yes, ma'am, he can refuse. If there is a show cause notice of 14 days will be sent, he will refuse if he will not allow if the company show cause anything that within 14 days that this charge shall not be registered. All the provisions of section 78 and the last message of show cause notice has to be written in this answer. All right. So this is section 82. I think section 82 we should do. DL Limited hypothecated its plans to the nationalized bank and availed the term loan. Everyone is clear on the previous question? Yes, correct answers. Plant has been given to the nationalized bank and taken a term loan. Company registered the charge with the ROC. Company settled the loan in full and requested the bank to issue a letter of settlement. So what is it happening? Satisfaction of the charge. Bank did not respond to the request. Now it wants to register the satisfaction of the charges, state the time frame within it. So it is very simple question, straightforward relating to satisfaction of charges. You have to tell them within 30 days it will apply. If not 30 days, how much will be the extension, children? If company fails to do it, yes, Tambeshwari, you'll get all the PPTs in a day or so, because now I have got the authority for the PPTs. So you'll get all the PPTs. Don't worry. 270 days, very good, are the extension, and 300 days from the date of the satisfaction of charge. Excellent, students, excellent. Section 87 also, I think we should do section 87 question also. ABC Limited created a charge in favor of OK Bank. The charge was duly registered. Most of the questions are from your module also, children, so don't worry. Later, the bank enhanced the facility by another 20 crores. Due to inadvertence, this modification in the original charge was not registered. Tell the course of action. What do you think will happen in this question? Answer me. What do you think will happen? Some rectification is required to be done. Central government's order will be required. Definitely, yes. The company is advised to file an application, and central government has the power. If there is any omission, misstatement, as it is, you have to write the language of the provisions. So you will simply say that they will make an application to the central government. If central government is satisfied that this was not made, it has been made erroneously, it has not been done fraudulently, then he will allow the rectification of registers. Now let's quickly jump to the MCQs. There is another question regarding satisfaction. I think we have done this one, satisfaction of charges. Yes. An interest on lien created on the property of the assets or undertaking of the security is known as debt, charge, liability, or hypothecation. MCQ 1 answers. I want everyone to answer these questions. So this is actually a test which I'm taking right now. Beautiful answers given by all of you. Miss Vishmita, BB Aisha, Nancy Balamurugan, Joya Praveen, all of you are correct, children. This is the charge which is created, is defined as there. Question number 2. Any person acquiring property on which the charge is registered under section 77 shall deem to have the notice of the charge from the expiry of 30 days, from the date of filing the application, from the date of acquiring the property, from the date of registration. MCQ 2. Any person who is taking the property on which the charge is registered shall deem to have the notice of charge from which date? Tell me. Absolutely correct. From the date of registration on which the charge is registered. So if the charge is registered, any person is acquiring, it will be deemed that from the date of registration, you are aware about this charge. Any person acquiring the property shall deem to have the notice from the date of registration. Very good, correct. A charge was created by C Limited on its office premises to secure a term loan of rupees 1 crore, availed from Next Bank Limited through an instrument of charge executed by both the parties. Inadvertently, the company could not get the charge registered with the concerned ROC within first statutory period permitted, and default was made known to the lending banker to take immediate steps for the rectification. Latest date within which the company must register the charge to avoid the paying ad valorem fees. Wow, what a question. 16th Feb, executed. Within 30 days, you should have gone. Then next 30 days, calculate. After that, next, how many days? You have to tell me, it's your test. It is C or D? What are you thinking? You're answering. B. Okay, ad valorem fees. Are you sure? Next 60 days. Arun Mishra, good. Pranav, thinking beyond. Very nice. So B is the correct answer. When the charge is created on or after 2nd April 2019 has to be taken consideration. Okay. There is some, it should have been on or before 2018 then. Let me just Just give me 1 minute. Let's see the exact question from the study material itself. So it says, this is your question, 27th April, 17th. So the date was 16th February. So right. So 16th March, 17th March, 30 days, and then 17th April, 60 days. So those who said B is the correct answer. 17th April, 2023 is the correct answer. Is that clear? Let's do one more MCQ from here. And then see. So the last MCQ, a person who cannot inspect the register of charges and instrument of charges during the business hours without paying the fees are members of the company, creditors, persons other than the member. No person is allowed to inspect. I want the answer for 5th MCQ. Lahari Moruji, you have not read the question. Dilip, you have not read the question. Chetna, right. Harshpreet, right. So this is what you do when you don't read the question carefully. Everyone has answered correctly. So C is the correct answer. Please listen carefully. He's saying, who cannot inspect the registers without paying the fees? Members, without paying the fees. Creditors, without, who cannot? So persons other than the members and creditors cannot inspect without paying the fees. Okay, have you understood? Correct? Rati Milani, Pallavi, Hardik, all of you have given the correct answers. Okay, children, now as promised, question number 10, you have asked me from the acceptance of deposits. So I'm going to do that as well. And then we will still, if we have time, we will ask you the questions. All right. Shubhra Chemicals Private. Now, this is acceptance of deposits, children. Question number 10 that you have asked me. Shubhra Chemicals Private Limited, not a startup company, is desirous of accepting deposits from its members amounting to 200% of the aggregate paid up share capital, free reserves, and security premium account. What are the conditions to be fulfilled? Now, before we jump into this question, since we have just finished registration of charges, I understand it will be very difficult for you to jump into acceptance of deposits. But let's have a quick revision. What was the limit set up for the percentage that you can borrow? Some 35% that you have learned. There was some 100% limit for the startup companies for 10 years, remember? Here it is borrowing up to 200%. What do you think will happen in this question? So I'm not going to ask you, I'm simply trying to explain you so that you can, in your free time, you can relax and listen to this lecture and you can understand what I've explained. So here they have specifically told you that it is not a startup company. Had it been a startup company, it is coming under the exemption of private companies. It is a private company, yes, ma'am. Private company, startup company, we have read about the exemption. But it is saying it is not a startup company and it is raising 200% means it is coming within the purview of no limits. So there were 3 characteristics to be satisfied for a private company in order to fall under this category. Let me go through the answer with all of you. It says, according to the provision, a private company may accept money not exceeding 100% of this, but the maximum limit which will be allowed will not apply to certain categories of private companies. Which were those? Number 1, if it is not an associate or subsidiary, if the amount of borrowing is less than twice the paid up share capital and 50 crore, whichever is less, and if the company has not defaulted. All the companies will file the details with the registrar in DPT3. This is about annual returns. So here we will assume that this is not an associate. Its borrowing is not exceeding. The repayment of borrowing has been made properly. So it shall file the details of the money so accepted in DPT3 form. So on the basis of the assumption that, see, children, if the question is not giving you full clarity, then you can give it in your assumption-based answers also. It is absolutely correct to give assumptions, okay? So in that respective question, question number 10, you simply write down that we are assuming that all these 3 points are satisfied. Then this private company will fall under the exemption of no limit. Otherwise, 100% tak ka limit tha. Now it is falling under the exemption where no limit is specified. Therefore, they can borrow up to the 200% limits also. All right. With this, we come to an end of our syllabus. Now I give you time to ask your questions. If you want to ask something, you want to discuss something, you want to talk about, you can feel free and you can raise your hands and I will allow you to unmute and speak. Let me see if there are any queries over here also. Bala Murugan, Bibi Aisha, everything clear, children? Nancy, Vismita V. All of you have answered very nicely. Nanda Goel says, clear, ma'am. Good. So, but I'm not going to leave you early today. I have to show you certain forms also, CHG 4 and CHG 5 as promised. So let me just show you these forms. So what was CHG 4 form, children? I forgot. Can you please tell me what is CHG 4 form used for? If you don't have questions, I have questions for you. What is CHG form used for? Chetna says clear. Nanda Goel, very good. Satisfaction of charges. So here is the CHG 4 form. Hardik, let me just show the forms and then I will give you a chance to speak. So this is how your instruction kit for e-form CAG4 particulars for the satisfaction of charges. This is how the form looks like. So about this document, section 82 and section 83 reference will be given. Where is section 83? If no intimation has been received. So here specifically section 82 will come within 30 days or within 300 days. Again, the same details, children. Remember, we have seen this CHG1 also, corporate identification number, pre-fill button. Same details have been given. The only difference is that here you are giving the attachments, check forms, how modifications have been made, important points, what is the capital, how much money has been paid. All these things will be given under the satisfaction of charge. All these kind of details, company having a share capital, not having a share capital, will also be filed along with this CH4 form. Okay, and what is the fees to be charged? Remember, 30 days, 60 days, 120. So more than 270 days, 30 times of the normal. So this is your ad valorem, how it happens. What are the charges that they're putting up as per the forms that they have given. And now let me show you the CHG5 form. What was CHG5 form? Can anyone tell me what is CHG5 form? CHG5 form is for the registrar is recording the satisfaction of charges. So the way they have issued for the modification of charges, CHG3, for the fresh registration, CHG2, same way CHG5, ROC will issue that this corporate identification number charge, this is to certify that the company only has been satisfied in full or part according to the provisions of Chapter 6. So ROC will only simply give you a certificate. These all are certificates that are given by the ROC that they have done all the satisfaction of the charges. You want to see CHG8 also? What was CHG8 used for? So we have seen all the forms in this chapter. CHG8 form is used for what? Rectification orders passed by the central government. Sukhveer, Kaur, Nanda, Dilip, Chetna, Hardik. I'm so happy answering so nicely and quickly. So the central government's extension for the time limit. So this is how CHG8 form looks like. The name of the company and other details will be given. You're making an application to the central government. Central government will go through this entire application. They will see if whatever delays that you have made, whatever instruments will be attached for satisfying all these details. It's a very huge form because you're taking orders from the CG. Central government is being involved. So you will give the drop downs values that I'm acting as the authorized representative. I declare everything that the delay was happened in filing the creation modification. No prejudice is happening to the charge holders. Want to see this? I'll just broad it for you. All these points that we discussed under the section that the company is not doing anything wrong, company is not into winding up, company is carrying on the business, no litigation proceedings are lying, no omission or misstatement was made to harm the charge holders or the other creditors. So all these kind of details have to be given. It is yes, these are electronic forms, Lahari Moruju, and they have to be submitted electronically. Form filled by the companies and the ROC means it is only yes. Absolutely correct, Nanda Goel. All right. So you don't need to learn about these forms, what are the contents, but yes, when we are doing these topics, you get curious to know what is actually written in these forms. And in rectification of charges, all the forms have to be learned. We have revised the form. CHG6 form was for what? Only 6 and 7 I have not asked you questions. Quickly answer me. What was CHG6 form used for? CHG7 was for entering into the register of members, for the entering into the register for the Register of Charges. What was CHG6 form? Who is the first one to give me the correct answer? Yes. For the appointment of the receiver or the manager, because it's the tiniest section. That's why you're not trying to retain it and remember it. And it's very small section that in which we have done CHG6 form. That's why I've not even shown you the form. It is just about the manager or receiver who will be appointed. Yes, Hardik, now you can speak and ask your doubt that you wanted to ask.
मैम सेक्शन क्वेश्चन 10 के रिलेटेड था, लेकिन मैम अब क्लियर हो गया वो, मैं
Okay.
खुद वो क्लियर हो गया।
Good. Any other doubts? Okay. Anyone else who wants to ask anything from registration of charges, children? I hope you have enjoyed the session and you are really going to revise it today itself, or maximum by tomorrow. You will make the notes. Don't forget to make the notes. Don't forget to make beautiful, colorful notes. Remember, I showed you, Saranj, that day, how beautifully ICAI has made all the summaries and short notes for you, and they're so colorful. And students, also, before you leave this session, you are requested to fill the feedback forms. I have received the request from admin over here. They have asked that all the students need to fill the feedback forms. All right. And thank you for the wonderful feedback that you have given in the chat box also. Thank you so much. Even I enjoy teaching you. Thank you, Nanda. Thank you, Chitna. Thank you, Hardik, Aisha, all of you. Please don't forget to fill the feedback forms. All right. When you log into the portal, the feedback forms come over there. All right, students. So thank you so much. All right. Thank you, Neeru. Thank you, Pranav. Thank you, Pallavi. Nanda Goyal is asking where are the feedback forms. So I have been informed that when you log into the portal, where you're while you log in, then where you send the admin queries also, there you can go and fill these feedback forms. Okay. Okay. Thank you, Lahari Moruju. Thank you, Praveen. I hope everything is clear to you. We still have 2-3 minutes if anyone wants to talk or ask any doubts. Thank you, Nancy, Bibi Aisha. Thank you, Joya Praveen. Thank you, Vismita. I'm glad you have enjoyed the session, all of you. All right. Sir, if you can just tell them where are the feedback forms, because few students are asking. Okay, good, Praveen. Thank you so much. All right, students, then wishing you all the best and good luck for your further preparations. Thank you so much. Yes, sir. I was just thinking, they were asking about where are the feedback forms, so you can just tell them maybe. All right. Thank you, sir.